Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV210710, Allstate v. Ecodry. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. We have read the briefs and have discussed this case in conference. And with that, counsel, you may proceed.
Thank you, Your Honor. May it please the court, my name is Sam Alaga. I represent the appellant, Allstate Vehicle and Property Vehicle Property and Casualty Insurance Company. The question before this court today is whether Ecodry, after taking a post-loss assignment of benefits from an Allstate insured, assumes the same obligations as the insured in addition to the benefits of that assignment that relate to that assignment.
Which obligations do you contend Ecodry took on? Surely not the obligation to pay the premium.
That is absolutely correct, Judge.
So,
only obligations that are related to the post-loss claim. So in this case, we're dealing with an obligation to sit for an examination under oath.
Yes, but are you aware of any authority that allows an assignee to pick and choose the duties they take on? Or an assignor to pick and choose which duty they assign without specifying that?
No, there's no authority that allows us as an assignee to pick and choose. And in this case, Ecodry, in fact, does abide by some of those obligations of the policy. Ecodry, when it takes an assignment, provides a proof of loss that insureds are required to provide. It provides an invoice to be paid. So those are obligations that an insured has, and Ecodry understands in order to get paid, they have to submit an invoice for the work that was performed. Another obligation is an examination under oath so that Allstate can adjust the claim properly and question an insured about the nature of the damage.
I think you may have misspoken a little bit, but maybe you hit on the important point. Allstate still has the ability to question its insured, does it not?
Allstate, I believe, Judge, has the ability to question the insured. It always has to be reasonable. And an examination under oath cannot be without any reason or basis. Anything an insurance company does has to be reasonable. So the question of whether Allstate, after Ecodry has already taken assignment, does Allstate have the ability to take an examination under oath of the insured? Can they do that? If it's reasonable, I think they can. But is it useful? It is not, because that insured does not have the information that Allstate would need to engage in arbitration or appraisal under the terms of the policy against Ecodry.
Well, arbitration is right out. I mean, Ecodry never signed an arbitration clause.
The policy contains an appraisal provision which
Ecodry never signed.
Well, Ecodry, when it takes an assignment, specifically the assignment says we have the right, you, the insured, are assigning us the right to pursue the claim against Allstate, including filing a lawsuit against Allstate and going to appraisal against Allstate.
Right. So they can file a lawsuit, but I mean, you just sort of hit on one of the other obligations that doesn't seem to descend with the assignment, and that's an arbitration clause. Ecodry never agreed to arbitration. So if Allstate demanded arbitration, on what basis could it do so?
The cases have been the opposite. It's always been Ecodry who has demanded appraisal under the terms of the policy, and I think the assignment itself specifically says that they are undertaking that right to go to appraisal under the contractual terms of the policy. So I think that
they're availing themselves of a right that the insured has because that's the right they took an assignment of, but they didn't take on the arbitration clause when they took that assignment, at least not expressly. You're going to argue that it's implied as a matter of law, and I'm interested in hearing that argument, but I guess my first question would be, Allstate and Ecodry seem to get into it a fair amount in the Arizona courts. Why doesn't the policy get amended to simply preclude this kind of dispute? Because that's certainly within Allstate's power.
I don't know the answer to that, Judge, but I don't know that it is within Allstate's power because of the Farmers versus Udall case has given the right to a vendor such as Ecodry to take a post-loss assignment of benefits even without permission or consent from Allstate. I don't think that Allstate or any insurance company can...
Well, Allstate could say in the policy, we will only pay, I mean, much like health insurers do, we will only pay providers who agree to our rules, including examination under oath, arbitration, whatever they want. They could say, those are the only providers you can use. We're not going to indemnify you. We'll indemnify you for a total loss, but we're not going to indemnify you for just any old billing provider who doesn't agree to play by our rules. They could do that.
And I think in a way the policy does say that. The policy does have a provision that says no one, not just the insured, but anyone can bring a claim or pursue a claim against us unless they comply with all the terms of the policy.
Well, that's the cooperation clause, which presumably would also give Allstate the ability to either deny a claim or even sue its insured under the cooperation clause if the insured doesn't cooperate with furnishing information or otherwise presenting legitimate bills. Right? I mean, Allstate still has that right.
I think that the clause that I'm talking about is different than the cooperation clause. That clause applies to anyone. The policy it does not say just the insured. It's under Section 1 conditions, and it says no one, not just the insured, may bring an action against us in any way related to the existence or amount of coverage or the amount of loss for which coverage is sought under a coverage to which Section 1 conditions applies unless there has been full compliance with all policy terms. This is a different clause than the cooperation clause that is in the policy that applies to the insured. So I think that what you're describing, Judge, is in a way already in the policy, and it's something that we've argued would apply to an assignee after a post-loss assignment.
Your brief relies heavily on an argument that without an EUO, Allstate is unable to ascertain the basis for the claim from Ecodry. Is that fair to say?
That is correct.
All right. And so how would the circumstance be different for Allstate if Ecodry had not received an assignment of this claim? In other words, if the homeowners decided we're going to ask someone to come in, do the work, we will bill our insurance ourselves and deal with. So you would not be able to request an EUO, but you'd still be able to investigate whether that's a fair billing, right?
That is correct, Judge, and that's a great question. I struggled with that question, to be honest with you, and I wouldn't file this declaratory relief action until I was able to answer that question. And the answer is when an insured brings a claim to the insurance company, the situation is no different. That homeowner has very limited information oftentimes about the work that was performed by the vendor and how many humidifiers were placed and why, and the compliance with IICRC 500 water mitigation guidelines. But if that insured were to demand appraisal under the terms of the policy, the balance is equal. That insured has certain knowledge. The Allstate adjusters can go and investigate and take a look at and inspect the loss after, of course, the water mitigation has been done. And to the extent that Ecodry provides invoices for this appraisal, or someone from Ecodry or the vendor comes in and testifies at that appraisal, it is as a neutral vendor who doesn't have, one way or the other, any stake in the outcome of that appraisal. But when Ecodry takes an assignment...
Well, they have a stake because they want to get paid.
Well, their contract in that situation is with the insured. They're going to get paid for the work.
They want to get paid, and most of the time, Allstate is going to have deeper pockets than the homeowner.
Sure.
Probably 99 times out of 100, right?
Well, I'd say 100% of the time, sure.
Okay, okay. So the vendor wants to convince Allstate that their claim is valid, right?
I would imagine that yes, but
So what's the difference in your ability to investigate if there's not an assignment of benefits?
I think when Ecodry is a party to that appraisal and has the ability to seek the benefits of the appraisal provision of the policy, or even sue Allstate in court, which they have done on hundreds of occasions, they have more of an incentive to testify, to have someone who is there at appraisal or in court and testify about what the work that was done. And if Allstate doesn't have the ability to at least depose or take an examination under oath of that individual prior to the appraisal hearing, it's certainly at a disadvantage.
Well, okay, but getting back to your earlier point that this is already in the policy, why doesn't Allstate then use that language in the policy, not worry about assignments, as a matter of law and the restatement of contract? Just say, it's told you in our policy we would only pay those claims where the vendor decided to play by the rules. The vendor now stands in your shoes. The vendor did not play by the rules. We're denying the claim. I mean, why not just rely on the actual language that describes the rights the insured has, rather than worrying about all of this implication in law?
So to deny a claim after a post-loss assignment because Ecodry won't submit to an examination under oath.
Well, if the insured wouldn't submit to an examination under oath, you might deny the claim, right?
Sure.
Okay, so now Ecodry stands in the insured's shoes, according to you. They're not playing by the rules. Why not just deny the claim?
Well, we filed a declaratory relief action in this case. So that's the option we chose to take. I think we would have been here probably by denying in that Ecodry would have filed a declaratory relief action or sued Allstate.
Well, perhaps they would have, but then you would have said you stand in the shoes of the insured. It's not that you took on an obligation independently to do what we say, Ecodry. It's that you bought something, you bought this right that had a contingency. That contingency isn't satisfied. I mean, wouldn't that resolve it within the four corners of the policy rather than have to worry about whether Arizona adopts a restatement doctrine?
It would have. I think we would have ultimately struggled with the same questions, Judge, and I think maybe the concern, it's a valid route to go, alternate route to the one we ultimately took, but I think the one additional concern that would have posed if Allstate denied a claim altogether is it could have potentially opened itself to a bad faith by the insured if we were wrong. So we wanted to know what are our rights and obligations, so in this case we filed a declaratory relief action to get that answer.
Yeah, I'm not being critical of the approach. I'm just trying to understand your position substantively, because the last thing I wanted to ask you about was this restatement rule that you rely on. I don't see how that rule, and maybe you can tell me, because greater minds have already thought of this, but I don't see how that rule ever became a majority rule and made it into the restatement. A contracting party decides what risks to take on based on the characteristics of the party you're contracting with, right? If all of those risks can be delegated without the consent of the contracting party, you sort of throw the economics of contracting into disarray. So it doesn't surprise me that Arizona hasn't really adopted this rule. I'm just wondering what the rationale is for subjecting that, unknown and unlimited risk on contracting parties in other states.
Well, I think when you take an assignment as an assignee, you know what benefits you are being assigned to you, certainly. So that is the benefits that you take, and you obviously pay something for the benefit of that assignment.
But the other contracting party has made a decision to take the risk that the duties under the contract will be performed or not. And they've done that by assessing the party they're contracting with. If that can just be fobbed off on anyone without the consent of the first contracting party, then all that risk assessment is kind of useless, isn't it?
Let me ask, it seemed from your brief that Allstate has taken the position that the restatement second of contracts rule that was mentioned in Norton was adopted by the state of Arizona. Is that your position? Was it adopted?
No, I don't think that it's adopted. I think it was looked at favorably at Norton. That's a 1981 case. It's the same year that restatement second of contracts was being finalized and ultimately published. And I think the Norton case looks favorably on that and also talks about Arizona's, because we recognize the validity of implied contracts, Arizona, that it would be logical for us to recognize an implied assumption of duties by an assignee, which is the position that restatement second of contract is proposing.
But the sentence immediately after that is that we don't have to decide that.
That is correct. The circumstances of this case do not require us to reach that question.
So is that not the very definition of dicta?
I think this is dicta, and I think that that is, no, I don't think Norton's binding precedent in this case. I think the Norton court, for the first time since 1925, the Arizona Supreme Court is struggling with this question when the judicial opinion with the restatement second is changing in this topic, and the court is saying it makes sense for us, but the circumstances of this case don't warrant for us to reach that question. And why? Because one, the assignment in that case in Norton was entered into 2 years after the performance date, so it was impossible for the assignee to perform the obligation that we were discussing. And two, that case involved a security interest assignment only, and the court went on to say presumably there's no assumption of duties when the assignment is as security only, and neither one of those
Right.
applies in this case.
Right. Let me ask you very quickly, because I see that we're running out of time, and I don't want to be the cause of it. But so, in as concise of terms as you can you tell us what liabilities, what duties Ecodry assumed when they accepted the assignment of benefits from the homeowners?
Only the obligations that have to do with the claim, the post-loss claim that they took on. So it would be to provide an invoice, proof of loss, to show what it is, what the damage is that they want to get paid, and to submit to an examination under oath.
And do you have that delineated specifically in the policy that for any claim that you submit, we will need the billing and an EUO?
Yes, there is a policy. Obligations are set forth in the policy that specifically tell the insured what they are required to do in the event a claim is made.
All right.
So, and last thing I want to say is that this court in Farmers versus Udall did discuss or address this issue. That is the case that gave Ecodry the right to take a post-loss assignment, and Farmers' primary concern in that case was exactly this situation, that after taking an assignment, Ecodry would be unhampered by the policy obligations, and they would pursue their claims unhampered by the policy obligations. And the court rejected that argument by Farmers and said, nor do we accept Farmers' related contention that the assignment allow Ecodry to pursue its claims unhampered by the policy's obligations. Ecodry conceded at oral argument it is subject to the same obligations under the policies as the insureds. And again, not binding precedent, but that is, I would argue, as strong of a persuasive authority as we can find just 4 years ago, involving the same vendor, same party that is in this case.
Am I missing something about Arizona public policy? Is there a reason, a legal reason that there can't be just a no assignment clause in the policy?
I think, I don't know about public policy. Public policy was argued in Farmers versus Udall, and this court allowed post-loss assignments
Yes, but if the policy were rewritten to say, no, we're not doing post-loss assignments, here's how we're going to pay you. Is there any reason that the policy couldn't be written that way?
I don't think that an insurance company can prohibit the insured and the vendor, or the insured, from contracting with another party. So I think there may be a public policy in prohibiting other parties from entering into a willing contract with someone else.
Right. We do know that post-loss assignments cannot be impaired by the insurance company. But let me ask you just one more question about how, in real terms, how would it happen if Ecodry or any other contractor was subject to EUOs? I mean, how would that affect the ability to transact business? Wouldn't they have to have like a whole division to investigate and fully be able to prepare for these EUOs, gain all of the information from the homeowner? I mean, it just seems like it would be very difficult to carry out business.
No, I mean, Ecodry has entered into, in the past, hundreds of lawsuits and appraisals, and they've had the manpower to have someone go and pursue those. And in this case, it would just take nothing more than someone who is involved in that water mitigation job, sitting for a short examination under oath, and just telling, as an expert, as someone in water mitigation industry, what is the damage that they saw and what is the scope of work that Ecodry did to support that invoice that they had voluntarily submitted to Allstate to get paid, and that's it.
All right, thank you,
Thank you.
counsel.
Good morning, Your Honors. May it please the Court, Josh Imke on behalf of Appellee Ecodry Restoration of Arizona. And before I get started on answering maybe some of these questions that were raised during Mr. Alaga's initial arguments here, does the Court have any questions for me?
Well, I think you know which one I'm going to ask. The policy contains some specific language that seems to work against the purity of the assignment as Ecodry envisions it. Why doesn't that policy allow Allstate to simply say, you're standing in the shoes of the insured, you're not playing by the rules the insured has to play by, we're denying your claim?
And that is a fair question. I think Your Honor previously answered that question when you raised the issue of Allstate Insurance had the ability to assess its risk when entering into the initial insurance contract with its insured. That risk being with the policyholder, not some third-party contractor years down the road.
Well, but then you guys come along and alter that risk by standing in the shoes of the insured and refusing to provide basic information to Allstate. I mean, I'm not suggesting that this is your position right now, but the net effect of this position, serially litigated, seems to be that Ecodry can just collect as much money as it wants without any oversight whatsoever. I can't believe that's consistent with Arizona public policy, and I also can't believe that's consistent with the language in this policy.
You're correct, Your Honor. It's not consistent, and that's not what has been happening. And that is what the Farmers Court addressed here 4 years ago.
Well, that's why I said I was careful to point out. I'm not saying this is your position here, but it does seem to be the long-term implication of your position.
There are rules in place. There are oversight committees. There is the Registrar of Contractors. Ultimately, what is required under the policy is that Allstate pay the fair and reasonable amount.
Also, what's required under the policy is that the insured cooperate, provide information, submit to examination under oath, and whether Ecodry actually assumed that obligation as its own, or whether it simply assumed that as a contingency on its ability to get paid in the shoes of the insured, I don't understand why that latter point isn't controlling here. Why does Ecodry have... I can understand the argument it doesn't take on obligations. What I can't understand is the argument that it doesn't take on contingencies.
Contingencies meaning what, Your Honor?
Well, the insured's right to get paid is contingent upon the insured's playing by the rules in the policy, providing information when required. Ecodry is saying we don't even have to do that. Our right is absolutely vested, apparently. That's your position. I don't see how you get there.
That's a really difficult position to take, Your Honor, because at the end of the day, if Ecodry or any other contractor is not able to support or justify the charges on its invoice, it's not going to get paid what's on its invoice. If they refuse to participate or provide that information to the carrier during the claims adjusting process, happens all day, every day, they justify their invoice, the charges, everything on it. If they're still not able to justify those charges, Allstate doesn't have to pay it. They're only required to pay that which is
Then I'm
reasonable.
stumped, because I thought you were here arguing that it doesn't have to submit to that process. It doesn't have to justify its charges.
If it wants to be paid what it's requesting, I believe it needs to justify its charges. It doesn't mean that it's subject to all of the other policy obligations that exist and are in line for the policyholder to participate in, such as an EUO.
Okay,
an
so is
examination
an
under oath.
EUO an obligation? We've been talking about this in terms of assigning benefits and delegating duties, and that's a traditional law school way to approach it. But under this policy, is the EUO an obligation, or is it a condition on the insured's right to be paid?
That is an interesting question as well. While there's no controlling case on that here in Arizona, there is a case directly on that point out of Florida, and it is the damage control v. State Farm case. And the court, I believe it was the Ninth Circuit Court in California, or in Florida, discussed that issue, and they were able to draw a differentiation between what a policy obligation is versus what a policy benefit is. Because the insured did not have the right to request an examination under oath of the carrier or the adjuster, it was a one-sided, a unilateral policy obligation. That's the way the court found that issue. Anything that is a bilateral obligation is also considered a benefit. And that's why the damage control court ultimately cited that the examination under oath portion of the cooperation clause in that policy is not transferable. And the interesting thing about that is you had raised the question previously as well of why can't Allstate just put into their policy some sort of language that requires anybody coming back and seeking payment under the policy to submit to an examination under oath?
And the answer was the policy does do that.
Interestingly, in the damage control v. State Farm case, State Farm's policy did exactly do that, very specifically. Required that anybody submitting payment or a claim or requesting payment under the policy submit to an examination under oath. The Florida court came back and said that's an enforceable provision, that's against public policy, that goes against everything that the assignment of benefits really has been for hundreds of years. It's literally just a transfer of post-loss benefits that have already accrued. The court went in to discuss the purposes of an examination under oath as well, and why an insurance company is...
This is all from damage control?
Yes.
The case that is a non-published trial court decision from another state?
Yes, and the Shaw court also discussed it.
That's thin authority.
But the Shaw court also discusses it, and the Shaw court was published. So it does talk about that in there as well. It is thin. Again, it goes directly on point to what Your Honor is requesting. Is it binding? No. I believe it is very persuasive. So as far as public policy, putting it into the policy like that was discussed. That specifically wasn't discussed during the Udall case, but what was discussed, and as Mr. Alaga brought up, was the concession, right? Farmer's contention was, with this assignment of benefits, Ecodry can bill whatever they want to bill without being hampered by the policy itself. And what was conceded at that oral argument was not that Ecodry is under the same obligations and all of the same duties and obligations, they have to perform those. What was discussed was more specifically about insurance fraud and overbilling practices. And what was conceded was Ecodry cannot do that. That's insurance fraud. That's against the law. There's oversight boards to prohibit that type of behavior and conduct. And it can't be done. That's what was conceded. not that Ecodry assumes all of the policy obligations on itself, can't do that. Did that answer your question?
Was that point briefed by the parties? I know that it came up at oral argument, but was it briefed?
I do not believe that that point was briefed in the Udall case, the farmer's case. And unfortunately, the oral argument that day it didn't record. There's no record of it.
Technically,
we've asked repeatedly for it.
So it's okay.
Yeah. And so, any other questions for me? No? Okay. So, at the end of the day, really what it comes down to is Ecodry, especially in this case, Ecodry received a post-loss assignment of benefits from the policyholder, Allstate's policyholder. Okay. Interestingly, Ecodry was deprived of the very benefit that it sought, which was to receive payment directly. Allstate didn't pay Ecodry directly. They paid the policyholder directly. After paying the policyholder directly, Allstate then sought to gain more rights under the policy than existed prior to the assignment, even after depriving Ecodry of that benefit, by seeking an examination under oath, which it didn't have the right to do before the assignment. So I think that's an interesting point here. As far as the appraisal goes and assumed risk or more incentive by Ecodry to participate, Ecodry's incentive remains the same regardless of the assignment of benefits. That is to get paid for its services. It fronts the costs of the services in exchange for the assignment of benefits, which, if the claim is covered, guarantees reasonable payment for those services. And so whether they have a greater incentive or not through the appraisal process, it remains the same. Again, it's important to really note what is really being requested here. And it's important to be able to distinguish, again, a transfer of a policy versus a mere assignment of post-loss benefits. It's two completely different things. The restatement that was cited to dealt with assignments of contracts, not assignment of contract benefits, but assignment of contracts. In fact, the Norton case also discusses that as well and differentiates between the two very, very well and clearly. So at the end of the day, really what Ecodry is requesting is that the court affirm the trial court's granting of summary judgment in favor of Ecodry at the trial court, and its denial of Allstate's motion for summary judgment. And with that, unless your honors have any other questions for me.
Well, since you have a little bit of time.
I do.
Maybe you could educate us as to the context in which this case arises. The examination under oath doesn't seem like such a big deal in an individual case, but there's some institutional reason that this battle keeps raging in all its many forms, right? I'm trying to understand the upside to Ecodry of playing it so hard and litigating it in court rather than cooperating at a transactional level. What benefit is it getting through this that it's not getting out of a straight voluntary transaction?
That question assumes that Ecodry is not cooperating at a transactional level to try to justify and support its charges.
Well, I mean,
which is fine.
You're at the Court of Appeals fighting with Allstate, so I'm assuming that at some level cooperation is broken down.
You could argue that. That's really not the way that it happens. Allstate just doesn't agree to pay a certain amount, and Ecodry thinks that's what their services are valued at. So there is, I would like to go back and discuss the examination under oath issues and why this is so important. You had Your Honors had raised the question of, wouldn't that require Ecodry or any other service provider to create an entire division just to answer examinations under oath? And Mr. Lager responded that, well, Ecodry has already litigated hundreds of claims, and they were able to handle that okay. That is true. Ecodry has litigated hundreds of claims. Ecodry has also processed tens of thousands of claims and only litigated a few hundred of them. The majority of the time, this isn't even an issue. But what the effect of a ruling supporting a transfer or an assignment of an obligation, such as an examination under oath, would have in this matter would be detrimental across the entire insurance services industry. Every auto body shop, every auto glass shop, every hospital, chiropractor, every doctor that dealt in an assignment of benefits would have to be subjected to sit for an examination under oath before they could be paid. Whether it's, again, property or casualty insurance like we're dealing with here, or it could extend to the medical side, but a lot of those medical providers will still take an assignment of benefits based off of a casualty insurance policy in a personal injury accident. So that would subject everybody to have to participate in an EUO. That would be detrimental across the entire industry billing
Detrimental
industry.
to what interest? The interest of maximizing rates? The interest of minimizing premiums? Which interest suffers?
It would, what it would essentially do is, man, it could have so many different effects. Every doctor that saw a patient would have to sit for an examination under oath. Again, you got to look at what the purpose of the examination under oath is. It's so that the insurance company can avail itself of information surrounding the cause of loss. What happened with the cause of loss? What was the extent of that damage? What was the policyholder's financial situation at the time prior to the loss, so that they can form an idea as to what the incentives or motivation behind the policyholder filing a claim was. Doctors don't know that.
That investigating the cause of loss is a very different process and very different objectives than investigating a claim for remediation or somehow addressing the loss once it's already happened.
Absolutely. Absolutely. Doctors can't answer that. Ecodry has, other than what was reported to it from a plumber or from the policyholder, they don't know what the cause of loss was. They don't know what happened, why it happened.
I'm
That's the
guessing
purpose of
Allstate
the
is less
EUO.
concerned with the cause of loss and more with the extent of loss. Right? I mean, there was a loss. Ecodry didn't cause it. The Allstate probably wants to pay Ecodry less than Ecodry wants to receive, and the purpose of the examination is to make sure that Ecodry is actually dotting its I's and crossing its T's when it provides the services. Wouldn't that be?
Yes, I think that would be a part of it.
Okay, and so long term, if that happens a lot, the effect of it is going to be to make Ecodry a little bit more conservative in its billing. And I think if it doesn't happen a lot, the effect of that is that Ecodry can be a little bit more, it can rest easy sending out whatever bills it wants. Isn't that really what we're talking about?
I believe the opposite would happen, Your Honor. I believe that if Ecodry were required to sit for an examination under oath under every single claim it submitted under an assignment of benefits, it would have to increase its costs and to cover its overhead for having employees have to sit for that.
Well, if Allstate actually subjected every claim to examination under oath, Allstate would have to increase its premiums, and then you just wind up seeing more ads for Geico. So
Very slippery slope.
So, I mean, as a practical matter, we can talk about every claim, but we're talking about sampled claims, really.
That's
in the
correct.
Real world, right? And so if you want to avoid that sampling, I'm just trying to understand why do that in this setting? Why not use the other devices we've talked about?
The other devices meaning an examination under oath?
A contract with Allstate, a participation in the rules of the game that the insured faces. Relying on antiquated restatement doctrines to take vague consumer assignments and transform them into exemptions from policy requirements seems circuitous. So I'm just curious.
No, it's a good, fair question, Your Honor. And there are, like I said previously, there are oversight committees in the industry. Ecodry is not able to just bill whatever it wants to bill to charge more money. There's guidelines that Ecodry has to operate within.
I have a quick question. And
In order to submit its
pardon me
invoices.
for interrupting, but we're coming down to the end. So in determining the extent of the loss, how often does the insurance company send someone to take a look at the loss prior to remediation?
Is Your Honor asking for a percentage of the time,
Just-
or?
I'm not in the insurance industry, so is that something that happens often? Is that rare? Because that seems like a ready way to determine what the loss looks like, and for someone who is a representative of the insurance company to say this has a ticket price of, this should be worth about X amount of dollars to repair.
Correct. Depending on the insurance company, that happens every day. Sometimes an insurance company can get an adjuster out there within a couple hours to be able to go and look at it.
Did that happen here?
I do not believe it did happen here. The claim was filed and opened prior to Ecodry ever starting services, so Allstate had the opportunity to get somebody out within a few hours. But there's also a portion of the policy that requires the policyholder to mitigate damages immediately. If the homeowner or a policyholder were to wait for Allstate to send out an adjuster, that might take a week. Well, now you're looking at a completely different loss. Now you're dealing with mold, now you're dealing with all kinds of problems, and Allstate would turn around and deny the claim because the policyholder failed to mitigate. Kind of a catch-22 there. But yes, Allstate is allowed, every insurance company is allowed, and they actually request under their policy the opportunity to inspect. Every policyholder is under the obligation to be able to provide pictures or allow access to the home so that that type of extent of the damage or scope of services can be determined. That is allowed, and they are afforded that possibility. Whether or not they avail themselves of that opportunity by getting an adjuster out there quickly depends on the insurance company.
Thank you very much.
Thank you, Your Honors.
Counsel, we thank you both for your arguments and your briefs. This matter is now taken under advisement, and we will issue a written decision in due course. We're at recess to get set up for the next oral argument.